Since the early 1960s, the United States Supreme Court has gradually expanded its power to adjudicate disputes over the distortion of district boundaries for political purposes, otherwise known as gerrymandering. In Shaw v. Reno, the court considered whether the irregular shape of a state's redrawn electoral districts amounted to unconstitutional racial gerrymandering. Following the 1990s population census, the state of North Carolina became entitled to a 12th seat in the United States House of Representatives. At the time, 78% of the voters in North Carolina were white, 20% were black, and 2% were either Native American or Asian. Based on the census, the North Carolina General Assembly enacted a reapportionment plan to redraw the voting districts in the state to provide for the newly acquired seat. Under the reapportionment plan, the Assembly created two districts that were comprised mostly of black voters. The first district was somewhat hook-shaped and comparable to a Rorschach inkblot test. The second district was even more unusually shaped, winding through the Interstate 85 corridor, crossing 10 counties and dividing towns into two separate voting districts. Ruth Shaw and 4 other white residents brought suit in district court against the United States Attorney General and others. Shaw argued that the reapportionment plan was unconstitutional because it arbitrarily created 2 congressional districts solely based on race. The district court disagreed and dismissed the complaint, concluding that Shaw failed to state a valid claim under the Equal Protection Clause. Shaw appealed the decision to the United States Supreme Court.